Hello everyone, welcome to our channel, and today we are going to look at law of contract 1. So before you go to the details, please tap on that subscription button below, and in case of any questions, let me know in the comment section. So in the contract law 1, we have three main topics. The first one is elements of a contract, we have privity of a contract, and we have contractual capacity. So first things first, we are going to look at elements of a contract. But before we go into the details, what is a contract? So in this course unit, the main act that is used is the Contracts Act. So Section 10 of the Contracts Act defines a contract as an agreement made with free consent of parties with capacity to contract for a lawful consideration and with a lawful object with intention to be legally bound. So just like the definition explains it, we find out that consideration is a major part in making a contract. There is something about legality, and there is something about consent of the parties. So when you're studying about the law of contract, there is something called laissez-faire. It is known as freedom to bargain. So the law presumes that the parties to the contract have enough bargaining power. So it is not the role of the court to make terms for the parties in that contract or in that agreement. It is just there to enforce the terms that were agreed upon by the parties. So first things, the first element of a contract is an offer. So there are majorly three. There is an offer, there is acceptance, and there is consideration. And these elements usually flow in that real order. The offer comes first, then acceptance, and then consideration. So when you're talking about an offer, the leading case is Carrill versus Carbolic Smoke Ball Company. It is an 1892 case. So put it off your fingertips. When you're going for any paper, make sure you do not forget that case. It is a leading case that illustrates what an offer is. So what happened in Carrill versus Carbolic Smoke Ball? So this was a company, that is Carbolic Smoke Ball Company, that was making smoke balls. So it made an advert in the newspaper saying that anyone that used their smoke balls and still contracted the influenza would be given compensation money. So that advert was put in a newspaper, and to stamp their deal, they also put that £100 were deposited in a bank specifically for compensating for those people that would still use their smoke balls and get the influenza. So a certain lady named Carrie, that is the plaintiff in this case, used their smoke balls as instructed but still contracted the influenza. So when she went ahead to enforce the contract, the issue before court was, can an offer be made to the public? Because here there was no specific agreement between Carrill and the company. No, this was an advert that was put in the newspaper. So after Carrill reading through all that and using the smoke ball, and she still contracted the influenza, now she came to enforce it against them. And the Carbolic Smoke Ball Company was saying an offer cannot be made to a public. But however, now the issue before court was, can an offer be made to the public? So court had to look at the circumstances. We all know that different cases have different facts, but when you're specifically looking at this case, you find out that a certain amount of money was put in the bank, that is £100, and it was specific that that money was going to work on compensating for the people that used their smoke balls and still contracted the influenza. So that was more of an assurance, because we know most of these adverts, it is just exaggeration to get customers and market for their goods. But this other extra step they went into by depositing that money was enough confirmation that this is actually an offer. So they were making an offer. So anyone that read upon that advert and acted as it said, and in case things didn't work out as it stated, then they had the right to be compensated. So court held that these are the arguments that an offer cannot be made to a public was wrong, because according to the facts of this case, this was an offer. So Mrs. Carril had to be compensated for that money. So that question brought a very huge contradiction and a very big question between what is the difference between an offer and an invitation to treat. So on that invitation to treat, we have a case of Fisher versus Bell. It is a 1960 case. So what is an invitation to treat? It looks similar to an offer, but it is not similar. They are just related. So an invitation to treat, as explained in that case, this was a case that happened through window shopping. This shopkeeper had displayed flick knives with price tags. So during that time, there's a rule that was prohibiting the sale of dangerous weapons to the public. So that those flick knives were part of the dangerous weapons because it was under the restriction of Offensive Weapons Act in the 1980. So now this customer, after finding the flick knives displayed with price tags, sued that shop for going against that rule. So the issue before court was, had this shopkeeper made an offer? And then court ruled that it was not an offer. It was merely an invitation to treat. So when you go to a supermarket and you find goods displayed with price tags, they are not making an offer to you. They are merely making an invitation to treat. It is you that picks up and you're like, okay, I want this Lato tin, and by that process you are making the offer to them. So when they accept, you now bring in the consideration. What is consideration? Consideration is simply the monetary value that someone gets in return for the promise they are giving you or for the good they are losing to you. When I sell you my bag, the consideration I get is money. I am losing my bag to you, but you are also giving me money as consideration in return for the bag. So let's go on with the offer. So how can an offer be terminated? When we are talking about terminated, we are looking at how can an offer be stopped. So there are a number of ways how an offer can be terminated. So the first one is rejection. So by rejection, simply as the term says, rejection, when I make an offer to you and you reject it, then that offer has been terminated. It has been rejected. So another way of terminating an offer is by a counter offer. What do I mean by a counter offer here? When I come to your shop and I say I need this Vaseline tin, and you, the shopkeeper, you make other terms on that offer that I'm offering to you. When I say I need this Vaseline original blue tin, and then you tell me I do not, that one is not on sale, it has already been booked, but you can take the pink one. So now the first offer that I made to you has been cancelled, and I am now making to you the new offer. So by that is a counter offer. I am making new terms, and those new terms cancel the first offer that you made to me. So now it is me in the position to accept the terms of the offer you're giving me, or there is no offer made at all. So a counter offer happens where I make you the offer, and then in return you do not accept that offer, but you propose new terms. That is how it goes. So another way of terminating an offer is by revocation. Revocation is simply as the word states, you're revoking it, you are going against it, you are not accepting it. So in those ways, an offer has been terminated. So since we are done with the offer, now we are coming to acceptance. So what is acceptance? Acceptance is you agreeing to the offer that I have made to you. So in this situation, there are two parties. There is the promisor and the promisee. The promisor is the one that makes the offer, and the promisee is the one receiving it, the one that has to accept it. So the promisee has to accept the offer. If I come to a supermarket and I pick this perfume tin and I say I need this tin, it is now the supermarket attendant to accept the offer and give it to me by telling me, okay, you can have it and this is the price. So by you accepting the offer, because there are instances where you go to buy something and they tell you, no, that one has already been booked, or that one is not on sale, or any other reasons. So they have to first accept to sell you that specific product. So still on acceptance, there is a major rule on acceptance. It has to be equivocal. What do we mean by equivocal? It has to state the exact words of the offer. If my offer was, can I have that blue mirror? The acceptance cannot be, yes, you can have the blue one. No, because now those are different terms. Or I cannot make an offer wanting to buy bread and you tell me, yes, you can have the donuts. Now those things are actually contradicting. You have to be accepting the exact offer that I made to you for us to be on the same page. However, still on acceptance, it came with a postal rule. The postal rule is because there is an exception to every general rule. So now the postal rule is an exception to the general rule on acceptance. So the general rule on the postal rule says that as long as the postal rule works with acceptance that is being made through letters. So as long as that acceptance letter has been deposited in the post office, even though it has not yet reached the person supposed to receive it, as long as I have put the acceptance letter in that post office, then that is the time when the acceptance of that contract has been made. So Lord Denning noted that when a contract is made by a post, it's clear law throughout the common law countries that acceptance is complete as soon as the letter of acceptance is put into the postal box, and that's where the contract is made. So still on acceptance, Section 7 says that acceptance of the Contracts Act, Section 7 of the Contracts Act, it realizes that acceptance is sufficient if it is communicated in any reasonable or usual manner. However, if the offerer prescribes a manner in which the acceptance is to be communicated, then it should be in that mode for it to be effective. So here there is a question of, you've made an offer to me, but how do you get to know that I have accepted the offer? So usually different modes of trade have common ways in which acceptance is made. So the law says that if you use a reasonable way that has been maybe like a custom in which that acceptance of a certain trade is used, then it is valid. However, if the promisor has made it specific that acceptance has to be made through this way, then it is only through that way that you can make it for the acceptance to be valid and effective. So still on the acceptance. We still know acceptance is you accepting the offer I have made to you. There is a general case there, and that is of Feldhaus versus Bentley. It is an 1862 case. So in this case, it was held that the auctioneer's silence did not amount to acceptance. So what does this case bring about? It brings about the rule that silence does not amount to consideration. Silence does not amount to acceptance. If I have made you the offer and you do not communicate in any reasonable way or in any manner that has been said, then your silence does not amount to acceptance of that offer. So how can acceptance be made? Acceptance must be in words. It can either be written or oral. But however, there is also an additional way of how acceptance can be made, and that is through conduct. If a certain way has been made or custom that if you accept this offer, maybe send a message or do a specific action, now that is by conduct. Even though you have not communicated orally or through writing, the performance of that conduct portrays that you have accepted the offer. So now we go to the last element of a contract, which is consideration. So what do we mean by consideration? Consideration is merely the price for which a promise is got. So the law of contract focuses a lot on commercial nature contracts, agreements that come with monetary value. It does not focus on these agreements that are gotten free of charge. So in the famous case of Carrera versus Misa, it is an 1875 case. It illustrates what consideration is. So in that case, it was defined that consideration is the monetary value for which a promise is got. I said to you my bank, the consideration I'm getting in return is the money, its price. That is the consideration. And then for consideration to be effective, it has rules that govern it. So the first rule is that consideration must move from the promisor to the promisee. What do we mean here? There are two parties, promisor and promisee. Promisor is the one giving you the offer, and promisee is the one accepting. So in this situation, the supermarket attendant is the promisee and the buyer is the promisor. So for consideration to be effective, the money, or that is consideration, should move from the buyer to the supermarket attendant. That is what that rule generally talks about. So there is a case of Dantok versus Pneumatic, and that case explains that rule. So in that case, it was held that the action couldn't sustain since the plaintiff had not finished consideration to the defendant. So the second rule that governs consideration is consideration must be sufficient but need not be adequate. So, like I already said, it is the parties to a contract that make their own terms. So as long as the other party is what is getting an economic value, as long as what you're getting in return has economic value, as long as it is sufficient, court is not going to bother to look at whether it is adequate or not, because at the end of the day, it is the two parties that made their terms of the contract which they were comfortable with. So another rule for consideration is that past consideration is not sufficient to sustain a contract. There is a case of Broscola versus Thomas, and that explains that rule. Then the last rule on consideration is consideration must be lawful. So what do we mean consideration must be lawful? We all know generally that the law cannot enforce an illegal contract. If there's an agreement between A and B and A is supposed to kill B's neighbor in return for 20 million, and A ends up getting the money without killing B's neighbor, B cannot enforce that contract against A in court, because at the end of the day, that was an illegal contract. So as long as that contract is not lawful, as long as it is illegal, court cannot enforce an illegal contract. It is, you complete those terms by yourself. If the other party doesn't do what you agreed upon, that is your own loss, because courts cannot enforce an illegal contract. It is one way of making the illegality legal if they still enforce such a contract. So that is generally about the elements of a contract, that is an offer, acceptance, and consideration. So thank you, and our next topic is going to be about privity of contract in the next video. Please follow up and please tap the subscription button. Thank you.